Good
morning, Realty executives.
Good morning.
All right, everybody's energized and ready. So thank you for being here. We have a really good morning to plan out quite a few things. And probably one of the biggest things that the reason we put this class together is because through the software that we put together, we found out that a lot of the people that had their home paid off, who had their home for 20, 30 years, they didn't have a living will. They didn't have the proper documentation in case there was, the inevitable was to happen. So we put this class together by, and one of our very own is going to give us an explanation of how things work out on living trust, the different power of attorneys. So please help me welcome William Waters to give us a great presentation.
Thank you, everybody, for having me here and giving this presentation. I think it's a presentation I enjoy giving because it talks about how we manage our assets. How I'm going to give you this presentation is I'm not going to go into details in terms of what a living trust is. I'm just going to give you examples how they can be used. Then we can talk about the details. So if you follow me, who's all married in here? And you took title on your property when you bought it as joint tenant with right of survivorship, right? Right? Okay. What's your name?
Virginia.
Virginia and I are married, and we like to go on trips. We like to travel. So we're going up to the Sierra Mountains, just traveling, and all of a sudden, boom, accident. I don't survive. What happens to the title of the property?
Virginia.
Goes to Virginia.
Lucky baby.
Right. And it goes that way because of the,
Right of survivorship.
that was created by the joint tenancy with the right of survivorship on how the deed was made out. Okay. Now, Virginia just continues to live life, doesn't get married again. We have children. And later on in life, Virginia, 90 years old, 100 years old, she passes away. What happens?
Probate.
Could that have been avoided?
Yes.
How?
Living trust.
Exactly. That's the difference between right of survivorship, which is joint tenancy with right of survivorship, and the revocable trust. However, there's only 3 ways to avoid. It used to be 2 ways, but recently, I think within the last 6 to 7 years, there's a 3rd way to avoid probate. Can you guys name them for me?
Living trust and the will?
That's one.
Will?
Nope. Keep that in mind. Nope. Keep that in mind. A living trust.
Power of attorney?
Keep that in mind, but it's not true.
Corporation.
Nope. Keep that in mind, but it's not true.
Oh, community, the deed, you mean via deed?
Sure. We have real estate. We're only talking about real estate right now.
Yeah. But I'm saying you could deed it,
How do you deed?
community
So,
property.
Nope. Nope.
Are they for investing on title?
What's the vesting on the title?
That's what I'm trying to remember.
There's only 3 ways. It used to be 2. There's only 3 ways to avoid probate with real estate.
There are some that survivorship.
That's 1. Joint tenant with right of survivorship, revocable trust.
Tenants in common.
Nope. TOD.
Transfer on debt.
There you go. That just recently came up about maybe 6, 7 years ago. I'm not sure about.
What is that?
It's a title. It's the way you can manage. It's a deed that you can transfer your property into. Basically, what it says is that I'm going to designate you as my beneficiary, and on my death, that's who the property is going to go to. It avoids probate.
And the person, I don't have to be on title, you just have to name it?
Mhm.
Is that correct? So upon death, it goes.
It goes to them.
Oh, wow.
It avoids probate. I have a copy of it, so it's a sample in your sheet.
That's
Yeah,
not,
let's transfer to it. Let's go through it right now.
that's part of the living
No,
trust?
no. This is an actual deed that you can fill out. It's called a TOD, transfer upon death. I put a copy in your.
Or,
Here it is, right
Oh,
there.
there you go.
Does that follow
All right,
like
guys.
pay on death, you know, that with
Nope,
your bank
nope.
accounts? I mean, is, did it
It's
same
acts like that. It's the
concept?
same concept with real estate as you would if you had a bank account. Okay? Now, do I like this? No. The reason I don't particularly care for it is because if I have children and the property needs to be divided up, it can only go to whoever that beneficiary is.
I don't look at the kid.
It depends who the kid is. If it's just one child, then it works. But if you have multiple children,
Yeah.
okay? But it does work. It'll avoid probate. Okay? So, those are the three ways that you can avoid probate. Revocable trust, joint tenancy with right of survivorship, and transfer of deed. Power of attorney. I'm going to give you a good example of why it didn't work. Had a client last year call me. I did a revocable trust for her. By the way, I'm not an attorney. Let me get that disclosure out here right now. All I do is prepare based on what you give me. Okay, so I'm not, I don't want to be accused of practicing law. I went to law school for a couple of years, but I wanted to make sure that. I had a client last year call me, Williams. My daughter's passing away. She's terminal. I need you to go talk to her and see what you can do about making sure her affairs are in. And so I said, when you say terminal, how terminal is? They said they gave her maybe 2 months to live. I said, okay. I said, is there any property involved? She said, yeah, they already have the property up for sale. I said, okay. So I said, who's the agent? So she gave me the agent's name. I called the agent. I said, I understand that you have this property listed and it's ready to go to sale. What have you done for preparation for her if she passes away? So she said, oh, we got a power of attorney. I said, okay. I said, if the property sells before she passes away, you have a power of attorney. That'll work. I said, what happens if she passes away tomorrow? Because they gave her, 60 days to live. What happens if she passes away tomorrow? Well, my broker said it's okay because we got the power of attorney. Was that correct?
No.
What happened? If she passes away tomorrow,
Power of attorney.
Goes to probate.
it goes to probate. A power of attorney is only good as long as the person is alive. Okay? When the person passes away, the power of attorney passes away. Okay? So I says, look, go to your broker, and I'm quite sure if he's worth his salt, he's going to tell you that when the person passes away, the power of attorney is going to pass away. That means you're not going to be able to avoid probate. Immediately, I already knew. When she told me she had a power of attorney, I started writing up the trust. Okay, because I already knew that it wasn't going to work, and what ended up happening, the daughter, the property was worth like maybe $200,000. The property sold for $500,000. Because I put the trust and had her go record the trust within a 2-week period, and record the deeds, record the property in the name of the trust, she was able to avoid probate, and the daughter, which was her only daughter, was able to receive the $300,000. Had I not did that, and that she would have passed away, we would have had probate. Probably still would have been in probate process because it takes forever. It's public. Everybody would have known her business, and the fees that she would have to pay the probate attorney were probably tremendous. Okay, that's why the power of attorney, it works. Now I'll give you a scenario where it did work. I have another client whose father was passing away. She called me, says, and she had already did the trust, power of attorney, the approval will, and the healthcare directive, which comes in the package of the trust. I says, go look in your trust that I did for you, pull the power of attorney, and go get the money out of the bank. Because she went to Bank of America, they said, well, you're not on titles. He wasn't. I said, go take the power of attorney that you have and take it to the bank. And I said, you'll be able to get the money. And she was able to. Even though the dad was still alive, he hadn't passed away. But because he was still alive, she had the power of attorney. She was able to go pull the money out of the bank so she can get this affair set up, even though she was going to receive a lot more money upon the sale of the property, or she had actually inherited the property. But she needed the money to help take care of his affairs after he passed away. And she was able to get that because she had a power of attorney. In that case, it worked. Why? He was still alive. Okay? So it works. It's definitely a good tool to have. A will. What does a will do? We all heard of them.
It just,
Instructions?
instructions,
Exactly. If you and I have a dispute,
How do we settle that dispute? Even though we got a will, how do we settle that? Who said that?
Courthouse, probate,
How do you get it read?
court order.
We got a will, and it tells us what we need to do, but if you and I can't agree, even though mom said this is what she wants done, and you and I sitting here fussing and fighting about it, which happens, how does it get read? That's why I like wills, but I prefer trust. Because what does that do? It puts someone in charge of the assets that were placed in the trust. So there is no dispute. If there is, now I'm not going to tell you that a trust cannot be contested. It can be, but there's a clause in there that if you do contest it and you're a beneficiary, you can be treated like you didn't exist if the successor trustee chooses to do that. That makes sense? So a will is good, but the only problem is with a will is that if there's an argument or something, how do you settle it?
Could you repeat that again, please?
A will is good, but if there's a dispute, how does it get settled? Especially if property is involved. I have a friend right now, he has a ton of apartment buildings, and I'm on him every day, put this in a trust. He still has joint tenants right of survivorship and a will. I said, but if there's a problem with a dispute, you gotta go to court. How do you get to court?
Attorneys?
With money?
What's that gonna cost?
With money.
Yeah.
That's why the trust is so valuable to me, because it reduces the cost associated with probate. That's the number one thing. And the reason, I'm gonna give you another example. I have a client who passed away 3 years ago. The mother did. And so they called me, and I've been telling them, I knew she was sick. I knew she had cancer. I said, look, you have this property over here. She's the only daughter. You guys need to trust. Okay, we'll do it. Procrastination. What happens? We all procrastinate. So she ends up in hospice. So they called me and said, we're ready to do the trust. I said, okay. I said, where's Miss Walker? She said, she's in the room. She's sitting there asleep. So I said, okay. Well, I just went in there. I looked at her. Miss Walker she's in hospice. She's got morphine. She got everything hooked up to her, man. I came back outside. I said, look. I said, I asked you guys to do this months ago, and you didn't do it. And I said, and as a result of that, she's on this hospice and on this medication. I can write the trust up all day long. I don't know a notary in the world that's going to go in there and sign it. So what ended up happening? Probate. That's why I hooked them up with a probate attorney, and the daughter, she ended up getting like $40-some thousand when she could have maybe got $80,000 almost. But when we got to the court fees, the attorney fees, recordings and stuff like that, she was almost out of $20,000. That's why I like the trust. I've given you examples of why you want to use a trust over a power of attorney, why you want to use it over TOD, which is a transfer upon death deed, and the joint tenant right of survivorship. All those things are good to have, but to me, ultimately, the trust overshadows that. Aretha Franklin, $80 million. She just died. $80 million. And 4 sons have to split that. But before they do that, they gotta go to court. James Brown, I forget what his assets were. Court. I think they still fighting over some of Michael Jackson's stuff. Michael Jackson had a trust, but it wasn't funded. When I mean funded, you don't have to have a recording at the courthouse or the county recorder in order for a deed to be legal. All the recording does is provide notice. Okay. He had the things. He had the trust, but none of it was recorded into the deeds. Not the record of the deed. You can have the deed as long as it's notarized. What makes a trust legal is that you have to have the legal writing, which is the trust. It has to be signed and notarized. Okay, and it has to be funded. Now, what I mean by funded, okay, I have a box right here, okay, I get this box, and basically I have all these assets right here that are in my name and my wife's name, joint tenant right of survivorship. So we decide we're going to take all these assets and we're going to put it in this box, because right now we own it. Right now we own it, right? So now what we're gonna do, we're gonna take it and put all these assets into this box, which is this trust. Now, we don't own it anymore. The trust owns it, okay? But because it's revocable, why is it revocable?
You could change it?
Right, you could change it. And what it says, even though I'm not the owner anymore, the person that put it in the trust, as long as I'm alive, which is called a settler, because I'm called a settler now, I'm basically selling my estate and put it in this box. Because I'm still alive, I have the ability to amend it, revoke it, or change it, which is the amendment, okay? In doing that, you constantly stay in control of what's in this box, okay? And the person that's going to be in control of this box is the person that's called the trustee, which it could be you or whoever you name, if you wanted to be the trustee. No? Okay, so if I'm the trustee of this trust, okay, I have the ability to manage the box. Okay, what happens is something happens to me.
To replace yourself?
Success.
You have a
Successor trustee. Okay, I've already named that person. When I develop the trust, I have a successor trustee. Okay, it could be my son, whomever I name. Usually somebody that you can depend on, because now they have the responsibility associated with the assets that are in this box, which is called the trust. Okay, so now if something happens to the successor trustee, hopefully you got a backup. So normally what I normally do is have two. Okay, if something should happen to the one person, then you still have someone that can manage this box. You could have also what's called co-trustees. Now, I don't have a problem with that. Sometimes I do, depending on the location. I have one client says, well, I want to name Johnny, he lives in Nevada. I want to name Susan, she lives in Las Vegas. And I got Johnny, and he's a sister, a brother, he lives in Colorado. Because of the distance, I don't like that. Because of a decision needs to be made, I can't wait for them to get plane tickets to get here to make that decision. So if they're close by, then I don't have a problem with co-trustee. But if they're geographically apart, then to me it doesn't make sense. So I kind of discourage that and try to get somebody that's going to be really local. Trying to think of some other things. We talked about the funding. We talked about the trustees. What can go into the trust?
Assets.
Properties, bank accounts,
Annuity.
health decisions.
What you say?
Personal things like vehicles,
Vehicles.
Jewelry.
you know.
Not necessarily jewelry, but you can name them in the trust. Okay. Anything that has a title to it. Real estate, car, boat, has title. Brokerage account. Stocks on a brokerage account. I have a client who did a trust for me. He said, I want everything I have in that trust. So what ends up happening is I can name them in the trust, but a lot of times the brokerage company have their own paperwork. They want to see the trust, and even the banks a lot of times, they don't want to see the paper, but they'll have their own paperwork that they use to place those items into your trust. Okay, so if you get a trust done and you need to go to the bank, just take a copy of your trust with you, and then they'll take it from there and place those assets into the name of your trust. Insurance policies, annuities. Why would I not put those in there?
Because you want them liquid.
Nope.
Those are the prepared documents that state, you know, why would it happen? You know,
You got life insurance?
No, life
No,
insurance.
because when you die, then they already
You
have
already have the name
instructions.
on it.
They already have
Whoa,
instructions.
whoa, what'd you
You already
say?
have the name on it.
That name is called what? Beneficiary. The beneficiary has already been identified, so you don't have to put that in a trust, because it's already been identified. Annuities, insurance products, they don't have to be put into it. Now, a lot of times, if I sit with a client, I say, okay, just to make for convenience, I'll put a tab in there that says insurance or miscellaneous, and I'll stick it in there, a copy of it in there. It's not part of the trust, but it's with the trust documents, because someone passed away. These are things that are going to become relevant. So they need to be in one place, you know. So, let's get to here. I don't know, I think I kind of covered most of the trust, power attorney,
So bank accounts, they ask you for a beneficiary, so you don't have to put a bank account on the trust if you already have a beneficiary?
You don't have to, but what you want to try and do is avoid any inconveniences associated with that. Because if you have a beneficiary on that account, it could take over 90 days for them to acknowledge it. You see what I'm saying? But if it's already named a part of the trust and it's already a trust document, the successful trustee can go in there because it's already part of the trust. You don't have to. The other item you can use is a transfer upon death, TOD, a POD, pay up on death. But even that one sometimes can take up to 60 days to actually have it effective.
So I have a question, because usually the properties that you want to put on the trust are the ones that are already paid off, that you're not gonna refinance, sell, or anything?
No.
So because it's more paperwork, so if I hear correctly, if you prepare the deeds, you put them into the trust, and even though you don't record them, they will still valid in case of passing, correct?
Mhm.
Okay.
But it has to be notarized.
Yeah, notarized and,
Now, the answer to your question regarding the refinances, the lenders want to see a natural person. They want to put the loan against a natural person. Even though a trust can be considered a person, but they want to put it against a natural person. So what they'll have you do, they'll have you take it out of the trust, put it into the name of the person that's doing the refinance. When the refinance is over, take that property and put it back in the trust.
okay.
They want to see a natural person
Right.
committed on that loan. So that's usually what you see happen with the finance. I'm not going to go into details about it because it can be confusing, and it's maybe not something necessarily for you guys to see. But in preparing the trust, the person that's preparing the trust, or the client, or the beneficiary of the trust, need to know how the property is going to be distributed. Okay, so do you guys understand what per stripes and per capita is? You've never heard of that term before? Okay. And you probably wouldn't hear it because it's not something, and the only time you'll hear it if you have, I have a client right now, I'm putting together a trust for a client whose husband has a beginning stage of Alzheimer. They have two trusts because they were married, they had trusts before they were married. Now that they're married, they want to combine them and create one. And so now you have these children that are associated with the beneficiaries combining them. So the question that I had for her and that she needed to give me was a breakout of the distribution. And so she says, well, I want him to get, basically she told me everybody gets $20,000 after selling the properties. I said, okay. What happens if he's not available or if he passes or predeceases this transaction? What happens to his share?
Is inherited?
Right. That's when you start talking about per stripes, per capita. Okay, and I may get this confused, because I wasn't going to bring it up before until I bring it, but you guys can go look it up. Write it down so you guys can look it up, and that way you can have a better understanding of what I'm trying. I may get them crossed up, but one's called per stripes, P-E-R, stripes, T-R-I-P-E-S, I believe it is. Per stripes, stripes, S-T, S-T-R-I-P-E-S. And the other one is per capita. Okay, there's two ways to make this distribution per capita. I'll take your question.
Oh, when you're done, can we go over like a scenario?
Yeah. Okay. Per stripes, and I may have them reversed because they're so similar. Per stripes says that Martine, Lionel, and Michael, I'm the deceased. Okay. Per stripes means each one of them get an equal share. So they get a third of whatever the assets were that I left behind. Okay. Now I may have it reversed. Okay, so per capita means that if something passed, if I pass away, right? The asset would not go to those three. It goes back to my family or whoever my brothers and sisters were. If I have brothers and sisters, my next closest kin.
Next of kin.
Yeah. That makes sense? Okay. That's important because sometimes they don't know.
And I'm not giving them legal advice, I'm doing the same thing, I'm kind of going over the same situation I would if I was sitting in front of a client. I need you to go look up the definition, really understand it, and then come back and tell me how you want this distribution to be made, and I'll write it up that way. But at least let them know that there is a way of doing that, because it helps with the trustee, because the successful trustee, they're not going to know all this. Unless, they're a lawyer or a paralegal like myself or someone or knowledgeable like yourself that may have this information. But say for instance the trustee names John Doe as a successor trustee, but he doesn't have the knowledge of distributions. Okay? But now, because she has already decided how she wants to distribute it per strata per capita, he doesn't have to worry about that. That make sense?
Yep.
Question?
I've heard the term AB trust. Does that fall in that?
You can, yeah. An AB trust basically is a trust that's divided, basically husband and wife, and it deals a lot with the taxes. That's why I didn't bring it up, because what I'm telling you, talk to you guys about are just basic trusts associated with real estate to avoid any type of probate. But you can set, there's all kinds of trusts. Okay, there's you guys know what an irrevocable trust is.
You cannot change it.
Why would you want to use that?
It's not good.
Oh, yes it is.
Well, yeah, because in case,
Yes it is.
in case you change your
If
mind.
you got a lot of money, it's really good.
Is that like foundations and stuff where you?
They use it to avoid taxes. I have all these assets here, but I don't want to deal with the capital gains taxes when they're sold, but I still want to benefit from it. So what I can do, I can put it in what's called an irrevocable trust. And basically what it's saying is I'm putting it in this trust, but I have no ownership whatsoever. It's not coming back to me. A revocable trust, it can come back to you, right? Because you can change it.
Right.
Once you put something in an irrevocable trust, it belongs to that trust. Whoever manages that trust, they manage it. But that's why I say you're talking about a lot of money, a lot of assets, and they use that a lot of times to avoid the taxes. The taxes. Okay. It's a tax. It's a strategy for taxes, just like you guys have heard of irrevocable life insurance trust. Never heard of that?
No.
Okay.
Part
Write this down. It's called an
Class
ILIT.
number two.
ILIT, irrevocable life insurance trust. And this is just some other information. This is dealing with investment stuff here. Then I'll go back to, this is the last thing I'll give you guys, and then I'll go back to the basic trust for your scenario. Life insurance trust is basically where we set up a life insurance policy, okay? And the life insurance policy is going to be large enough so where if I pass away, the capital gains tax associated with all these assets, that life insurance will pay for it. Again, we're talking about a lot of money. A person that has a lot of assets, they will use that as a strategy. I'm not a tax preparer. I understand taxes, but I don't do for taxes. I would tell you to go talk to your tax preparer if you want more information on something like that. Tax strategy associated with avoiding taxes. Your scenario.
On an irrevocable trust, can we manage that account or has to be somebody else?
You're the manager. You decide. This is how it works. What's your name?
Jose.
Jose. I come to your house and you say, you know, William, I want to develop a trust. I say, okay, first thing I'm going to say, okay, what are the assets? You're going to say, I have this apartment over here, I got this 4 unit over here, I got this 5 unit. And I'm going to say, how are they held in as far as title? You're going to say joint tenants or right of survivorship, or either this is sold and separate property. And I said, okay, we can do that. I said, now, who's going to be the trustee of this trust? You're the settler. You're basically saying, I'm going to settle my affairs as far as this asset and put them in this box. Now, the next question I'm asking you, who's going to manage that box? Obviously, you're going to say you are. It's your stuff. Okay? The next question I'm going to ask you is, something happens to you, who's going to manage that box?
Successor.
You name that person. And I'm going to ask you, if something happens to him, who's going to manage that box? It's a backup. Okay? So you got this box with all this stuff in it that we're getting ready to go make sure that, you know, you don't have to worry about probate. Because again, the whole idea is to avoid probate. Okay, that's the only reason we're here talking today, is how do we avoid probate. We know 3 ways of doing it. The revocable trust,
joint tenant with right of survivorship, and tenant, transfer upon death, deed. Okay? And by far, the trust, I think, gives you more flexibility and more control than those other two. Did I answer your question?
I have a question.
10 minutes? Okay.
Okay, in case the property is on the title of real estate trust, or there's a bunch of investors as tenant in common, or tenants in common, so how do you put your portion in the trust?
You have, now I'm not sure how it's divided, but it's some documentation somewhere shows that you have a certain interest in that property.
Right,
You can record that interest in that property into the trust.
okay, so you do the deed from your
Perspective from your portion of, because
My
you do.
portion, put it into the trust.
Mhm.
Yeah, because when there's a lot of people like.
Because even if
REITs,
it's, right, even if it's a REIT, you still have a certificate of some sort. That
Right,
says that, so the name, instead of the name being in your name, it'll be in the name of your trust.
got it. And you
Because the REIT, it's got something on there that has your name personally on
could-
it.
Right, right.
So instead of your name being on it, it's gonna be in your trust. So something happens to you, they can always go back to that REIT and say, he's not here, but here's his trust. What's his interest?
Got it.
Okay, makes sense?
So tenants in common, same thing, because you have your
Yeah.
portion there, so you just need to deed your
Yeah,
portion.
it's a tenant in common. Martine is a tenant in common with William Border Trust. Not William Border, the trust.
Right,
Then, so when someone looks at my trust, they'll say, okay, you have an interest in some property and it's located in such and such. And when they go look at the title, they're gonna say joint tenancy, but the tenancy is gonna be, the other joint tenancy is gonna be the trust, not me.
got it.
Scenarios or not yet? Go ahead.
What scenario you want?
I have this friend, right? His dad passed away.
Go ahead.
Left him the property. He
Yeah.
has a brother, but left the property to him. His mom's still alive, but she's very bad also. He decided to change the deed to both him and his brother for being Mr. Nice Guy. Everybody told him he should have never did that because his situation right now is he would love to sell it because he's in need of money, but the other brother is well off and has a home sitting there empty for about 4 years now, and it's more sentimental to him. Like he's gonna leave it there because whatever reason he has sentimental. But the other brother needs money. What should his next steps do to force him to sell, or can he?
The property is titled in what?
And both of them.
I don't know.
Tenant in common, joint tenant, well, it can't be joint tenants, because, that's what, to make sure you understand, joint tenancy is effective 4 ways, and I forget the 4th one, but it's gotta be time, they got to sign at the same time on the deed, they have to both have the equal interest in the property is the second one, I forget the other 2, but there's only 4 ways that you can have joint tenancy. You guys gotta look that up.
Equal shares.
Equal shares, and there's a 3rd one, I'm not sure what the 4th one is. But I'm not sure, the first thing I would do is start off, number 1, how's it titled? Okay, how's it titled?
As
If
a
it's
real-
joint tenancy
yeah.
with right of survivorship, both of them would have to sign in order for anything to be done with the, as far as the trust is concerned.
How about tenants in common? If it was a
But
tenant,
let me finish this fact.
I mean, what's his next step? Let's say vesting is how it's supposed to be. Can he pay a lawyer? I mean, is that his next step? He has to pay money, which he doesn't have? But is this his only option to force his brother to sell?
He can't, I would just seek the advice of an attorney, but just from what you're telling me, depending on depending on the title, if he's tenant in common, he can sell his interest and he doesn't have to get approval from his brother. But I don't know what the title is. That's why the title is so important. If it's tenant in common, that means depending on our interest, if I have a 50% interest in tenant in common, I can go sell my interest to Ryan and I don't have to get his permission to do so.
Yeah, let's throw that one out the way because somebody might not want to get into that situation.
Okay, exactly. Yeah, you'd be surprised. Yeah, but I hear you. Go ahead.
Yeah. So, but can he force his brother to sell? Because he's in need of money.
No.
No?
Shouldn't matter.
Again, it goes back to the title. It goes, see, what's important is the title, is the ownership. What does he own? The court's the first thing he's gonna say, what does he own? Why are you bringing him into court? Does he own this? Does he own it outright? Does he have a certain interest in it? So it starts there. It starts there.
Everybody's
So,
tenant enjoying income.
One more question, Mike, tell me I'm done.
I was just gonna
Oh,
say, you put a quick claim
I put
deed
it,
here.
look at the last page, look at the last page. We're talking about funding. This is my mom and dad's property before I sold it. My mom passed away, we were talking about joint tenants right of survivorship. Okay, William and Connie Borders, that's my mom and dad. I did the trust for them, and I forget, I don't see the date on there. I did the trust, and we recorded it. And the reason I'm showing you this because this is what a document looks like when it's recorded. It didn't have to be recorded, but this is what happened. And you can see where it went from there personally as joint tenant with right of survivorship, because both of them are on there, and they actually put it into the trust. Now, my dad passed away not too soon after, not too later after that. I think in 2001, my dad passed away and left my mom with the property. My mom passed away last year, and the trust worked tremendously. No court, no probate, no nothing. Only thing I had to do was call the reverse mortgage people and told them she passed away. They said, how much time do you want?
Sorry for your loss.
Thank you. But it worked. And I use that as an example so you guys can see that it actually worked. Okay. It's working today. I got some more clients that was working. And I shared that with you already. That's it for me. I don't know if you guys have more questions, just call me. 323-331-6096.
Again,
once again,
323-331-6096. I left my cards in my car, it's sitting in my driveway. Battery won't work. My neighbor had to bring me down here. I got to get Uber to get home. William Waters.
All right, guys, give him a big round of applause. All right, so was that awesome or was that awesome? Okay, so
What it looks like.
I've been doing this for 20 years, and I know that it always go back to title. It always, we've been told that since we took our licenses, we took our training. So it's very important that now when somebody asks, how do I vest title, you give them a list, right? They can make a choice. But if they want a reference from somebody to somebody that can help them make that decision, here's somebody that can, or if you have somebody else, refer them to it. It has a lot of precautions. So that was awesome. It was great information. And so I have a question for you guys. Do you want to see part 2?
Yeah.
You want to see part 2 too? All right. So we'll talk to William and we'll find out a time when he can come back. Now that you know what you know right now, I know that there's a lot of questions right now. There are scenarios that you would like to play out. Maybe even one that is real that your clients have. Write it down so that we can bring it to him and he can break it down when he does his second presentation, and you can get clarity, and in the meantime, help a lot of other people. So I know a lot of people, the video is going to go online. We're going to put it on our YouTube channel for anybody that you want to refer this to. Go ahead and you can send it to. It'd be very easy. Anyone watching that wants to attend, whether you're an agent or you're a private person that wants to know about this, come on over and learn from us. Kate over here in the office, give us a call, 562-925-1111. That's our main line, so that you can RSVP and get over here. So I thank you so much again. I love it. I really like this information, and I can't wait to learn more. So thanks, everybody.